Welcome to our deep dive. If you're joining us, pull up a chair at the table. We are thrilled to have you here. Okay, let's unpack this. Today's deep dive is about the high-stakes world of third-party beneficiaries and creditor rights. Imagine this scenario. Someone owes you a substantial debt. You've done the work, you've delivered the goods, and you're just waiting for the check to clear.
Right.
But suddenly, a brand new party steps into the picture. Maybe it's a corporate buyout, or maybe it's just a wealthy backer. And they promise the original debtor that they will pay your invoice. What happens to your rights as the creditor? Do you have to pick just one person to sue, or can you go after everyone? It sounds like a simple question of debt collection, but as we'll see, it strikes at the very heart of how contract law balances rights, remedies, and the absolute limits of liability.
What's fascinating here is how the law evolved to handle this exact dilemma. Today, our analytical path is going to dissect a concept known as the doctrine of election of remedies. Along the way, we are going to tear down the outdated, confusing theory of implied novation.
Which was, a massive trap for creditors.
A huge trap. It caught unsuspecting creditors for decades in the 19th and early 20th centuries. And finally, we will build up the modern rule of joint liability under the restatement of contracts, which fundamentally shifted the power dynamic back toward the party who is rightfully owed the money.
That sets the stage perfectly. Before we dive into the specific case law that changed the game, let's establish the doctrinal foundation. When a new party promises to assume an old debt, what is the governing legal principle for the creditor looking to get paid?
The governing principle is found in the Restatement of Contracts, specifically Section 141. The general rule dictates that a creditor who is rightfully owed money does not lose their claim against the original debtor just because a new party also promised to pay it. The rule explicitly identifies three distinct testable elements. First, there must be a creditor-beneficiary relationship with an enforceable claim. Second, there is a recognized right to obtain a judgment against either the promisee, the promisor, or both of them. And third, there is the absolute limitation of a single, complete satisfaction. You can hold multiple judgments on your wall, but you can only get paid the full amount once.
To see how this actually plays out in court, let's analyze Erickson v. Grande Lumber Co. First, what are the legally dispositive facts?
The facts here outline a classic, messy corporate debt assumption scenario. The plaintiff was a creditor who was owed a significant amount of money by the Grande company, which was a lumber operation.
And they had a valid contract.
Unquestionably. The plaintiff had done business with them, and Grande had a legal duty to pay. Subsequently, a new entity, the Stoddard Company, entered the picture. Stoddard acquired assets and essentially took over operations, and as part of that deal, Stoddard explicitly agreed to pay Grande's existing debts.
So Stoddard steps into the shoes of the lumber company, financially speaking. But I'm guessing the check still didn't arrive in the mail.
Precisely. The plaintiff, looking to collect what they were rightfully owed, decided to go after the entity they actually signed a contract with first. They took a judgment against the original debtor, Grande. However, Grande was likely cash poor at this point, so that judgment wasn't enough to satisfy the debt.
Right.
Realizing this, the plaintiff pivoted and is now trying to also get a judgment against the new entity, Stoddard. Stoddard naturally wants no part of this and argues that the plaintiff already made their choice.
And what was the core legal issue?
The precise legal question before the Oregon Supreme Court was this: does a creditor-beneficiaries act of taking a judgment against the original debtor, the promisee, constitute an election that precludes them from subsequently seeking relief against the new promisor?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule formulated in Restatement of Contracts, Section 141, bolstered heavily by Williston on Contract Section 393. The full black-letter rule states that a creditor-beneficiary who has an enforceable claim against the promisee can get judgment against either the promisee or the promisor, or against each of them on their respective duties to him, but satisfaction in whole or in part of either of these duties satisfies to that extent the other duty. The rule has three elements. First, the existence of a creditor-beneficiary relationship. Second, the right to multiple judgments, which fundamentally rejects the theory of implied novation. And third, the limitation of a single satisfaction.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the existence of a creditor-beneficiary relationship?
Let's look at the sub-issue here, which is proving the plaintiff is actually a valid creditor-beneficiary. The sub-rule defines this status clearly. It exists the moment a promisor, which in this case is a new party, agrees to pay the debt owed by a promisee to a third-party creditor.
So looking at the application of the facts to that rule.
Right, the court noted that Stoddard, acting as a promisor, explicitly agreed in their acquisition deal to pay the debts that Grande, the promisee, owed to the plaintiff.
So the plaintiff didn't need to sign a new contract with Stoddard. Stoddard's promise to Grande was specifically meant to benefit the plaintiff, locking them into that status.
Exactly. The plaintiff didn't suddenly become a direct party to the buyout contract, but they were the intended beneficiary of that specific financial promise. Therefore, the conclusion for this step is clear. The first element is met. The plaintiff firmly holds the status of a creditor beneficiary with an enforceable claim.
Understood. Now, what about the second element, the right to multiple judgments versus implied novation?
This is where the legal heavy lifting truly happens. We really need to spend some time here. The core sub-issue the court had to answer was whether the plaintiff's act of suing Grande meant they legally elected to release Stoddard from the debt.
Because Stoddard's lawyers argued they did.
They did. But the sub-rule applied by the court is that the weight of modern authority gives the creditor independent rights against both parties, not merely a choice between them. To understand how radical this application was, we have to look closely at the defense Stoddard's lawyers put up.
They came armed with some older precedents, didn't they?
They absolutely did. They relied heavily on 19th century cases like Bohannon v. Pope out of Maine and Wood v. Moriarty out of Rhode Island. Those older cases operated on a rigid, frankly flawed philosophical premise called implied novation.
Okay, let's pause there. What exactly is a novation, and why is it a trap for a creditor?
A true novation in contract law is a total substitution. It means tearing up the old contract entirely, throwing it in the fire, and writing a brand new one that replaces the old debtor with a new one. The original debtor is completely released and walks away free and clear.
So Stoddard's defense argued that the new promise was basically an offer for a novation.
Yes. Under the logic of cases like Bohannon and Wood, if the creditor sued the original debtor, Grande, this act implicitly rejected the new promisor, Stoddard. Conversely, if they had sued Stoddard first, they would have implicitly released Grande.
It's like a bad magic trick. The original debtor throws a smoke bomb, a new corporate entity steps in, and when the smoke clears, the original debtor has vanished.
That is the perfect analogy.
And the courts were telling the creditor, well, you accepted the new guy's promise, so you implicitly agreed to let the original guy disappear. That sounds incredibly unfair to the creditor, especially if the new guy turns out to be broke.
It was toxic for commerce. It forced creditors to play a game of financial roulette. The Oregon Supreme Court entirely rejected this framework in their application. To do so, they turned to Professor Williston's authoritative treatise on contracts.
What did Williston say about it?
Williston explicitly calls the implied novation theory erroneous. He points out that forcing a creditor to choose misunderstands the very nature of the contract. The promise made by Stoddard to Grande created an additional layer of security for the creditor, not a substitute. It was a collateral undertaking.
Right, because why would any rational creditor give up a sure claim against an original debtor just because a stranger made a promise?
They wouldn't. It would paralyze lending and supply chains. If we apply that rigid 19th century logic to modern commerce, it would mean every time a company is bought out, all of its creditors are forced to guess whether the new parent company is solvent before they even file a lawsuit.
If they guess wrong, they lose everything.
Precisely. And the defense knew their argument was based on dusty precedent, so they also tried to cite a more recent case, Verrill v. Weinstein. They argued that a promisor is basically just an agent for the original debtor. The logic being, if you sue the principal, you can't also sue the agent.
But the Erickson court wasn't having any of that either.
Not at all. The court dissected Verrill and found it was factually distinguishable. It was actually about statutes of limitations, not foundational liability. The court clarified that the new promisor isn't acting as a mere agent. They are taking on an independent obligation to pay a debt of their own making as part of whatever deal they struck with the promisee.
So they just methodically dismantled these old defenses.
By systematically taking down the Bohannon, Wood, and Verrill arguments, the court adopted Williston's view completely. Suing the original debtor does not reject the proffered new promisor. There is no election of remedies required because the remedies are not mutually exclusive, so the conclusion for this second element is unequivocally met. The plaintiff has the absolute right to pursue and obtain judgments against both Grande and Stoddard simultaneously.
And what about the third element, the single satisfaction limitation?
Here is where the court balances the immense power they just confirmed for the creditor. The crucial sub-issue is whether the plaintiff can collect the same debt twice. The sub-rule states that satisfaction in whole or in part of either duty or of judgments thereon satisfies to that extent the other duty or judgment.
Essentially, this is the anti-windfall provision. If I collect $4,000 from the original debtor, my $10,000 judgment against the new guy instantly shrinks to $6,000. I can't double dip.
You've got it exactly right. In applying the facts to this rule, the court is protecting the defendants from unjust enrichment. Yes, the plaintiff is allowed to hold two judgments simultaneously, one against Grande and one against Stoddard. But the law strictly prevents double collection. Every single dollar collected from one entity reduces the liability of the other entity in real time.
So the element is met.
The conclusion here is that this element is met. The court affirms the protection. The plaintiff gets exactly what they are owed, but not a penny more.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the court's ultimate holding was absolute. The plaintiff is entitled to maintain the action against both the promisor, Stoddard, and the original debtor, Grande. The plaintiff is entitled to judgment against both of them, but is strictly limited to only one complete satisfaction of the underlying debt.
They can cast a wide net, but they can only pull in the exact amount of fish they were initially promised.
Precisely.
Here's where it gets really interesting.
Yeah.
Let's take all of that complex doctrinal theory, step away from 1920s lumber companies, and drop it into a visceral scenario you might actually face today. Imagine this. You hire a shady bio-waste disposal company to remove 500 barrels of leaking, foul-smelling, toxic sludge from your backyard.
Sounds lovely.
It's a nightmare. They owe you this service. It's a legally binding debt of service. But before they do the work, they sell their entire business to a sketchy new syndicate called Mutant Inc. And Mutant Inc. promises the original company that they will step in and handle your toxic sludge problem. Meanwhile, the sludge is actively seeping into your lawn, ruining your property. Panicking, you immediately sue the original company to force them to do the job. But now, the hazmat suits from Mutant Inc. don't show up either. Can you also sue Mutant Inc., or did you forfeit that right the moment you filed the first lawsuit against the original company in your panic?
Applying the law from Erickson to this incredibly gross hypothetical, the answer is a resounding yes. You absolutely can sue Mutant Inc. as well. You do not have to pick just one company to sue, and you certainly aren't trapped by your initial panic to hold the original guys accountable.
So no implied novation trap.
Under the restatement rule, there is no implied novation bad magic trick forcing you to choose between the original shady company and the sketchy new syndicate. You didn't release Mutant Inc. Just by trying to hold the original guys accountable first, you are a valid creditor beneficiary of the promise Mutant Inc. made during their buyout.
So I don't have to tear my hair out worrying that I sued the wrong corporate shell.
Exactly. You can march into court and get judgments against both companies simultaneously to force their hand. You can leverage the full weight of the legal system against both entities.
But I can't get 1,000 barrels removed.
Right. Applying the final element of our rule, you cannot force them to remove 1,000 barrels of sludge. You only have 500 barrels. You are entitled to judgments against both, but you only get one complete satisfaction of the 500 barrels removed.
That perfectly illustrates the power and the boundaries of this rule. Now, to make sure this completely sticks, let's crystallize everything we've discussed today. How should we map this out for practical application?
Let's synthesize all the rules from our deep dive into a step-by-step diagnostic checklist. Whether you are outlining a high-stakes exam answer or spotting issues in real-world commercial litigation, this is your 4-step framework. Step 1 is identify the status. Always look for the foundational relationship first. Is there a promisor stepping in to pay a promisee's debt to a third party? If the answer is yes, you have a creditor-beneficiary scenario, and the restatement rules apply.
Got it. What's step 2?
Step 2, spot the trap. This is crucial. If a defendant argues election of remedies or implied novation, essentially arguing that by suing one party you automatically release the other, you must strike that argument down. Recognize it as an antiquated defense and cite Restatement Section 141 in Williston to dismantle it. Remind the room that a new promise is an additional security, not an automatic substitute.
Okay, step 3.
Step 3, assert joint rights. Confidently conclude that the plaintiff has the right to pursue, maintain actions against, and obtain judgments against both the promisor and the promisee. Emphasize that these are independent duties owed to the creditor.
And the final step?
Step 4, apply the limiter. Always cap your analysis by explicitly stating the boundary of the law. The plaintiff is incredibly powerful, holding multiple judgments, but they are absolutely limited to a single, complete satisfaction of the underlying debt. Missing this final step means missing the fundamental balance of contract law.
So what does this all mean? For you, the listener, it means you never have to let a debtor off the hook just because they tried to pass the buck to someone else through a corporate buyout or an assumption agreement. The law recognizes that a promise made to pay your debt is an asset for you, not an excuse for them. You have the power to cast a wide net and hold everyone who promised to pay accountable.
If we connect this to the bigger picture, this evolution in the law is a masterclass in balancing fairness. By rejecting the implied novation trap, the legal system protects creditors from shell games. It ensures debtors can't easily evade their responsibilities by transferring obligations to less solvent third parties and disappearing in a puff of smoke.
But they also don't get a double payday.
Right, by imposing the single satisfaction rule, the law simultaneously prevents unjust enrichment. It ensures the creditor is made whole, but prevents the legal system from being used as a tool for a windfall double recovery. It's a remarkably elegant solution to a very messy commercial reality.
It really is.
Yeah.
But it leaves you with something to chew on. If the law says you can hold active judgments against both parties but only collect once, how do you decide whose bank account to empty first? And does holding a judgment against two desperate companies incentivize them to hide their assets from you? Or does the intense pressure turn them against each other in a race to see who takes the financial hit? It's a fascinating strategic dilemma to consider next time you're trying to collect a debt. Thank you for joining us at the table today, and we'll catch you on the next deep dive.